Okay, hello. This is, I believe, 8th remark concerning the series of remarks entitled Introduction to Business Immorality and Corporate Social Irresponsibility, selected topics. And this, the last remark was the 7th, was concerning the acquiring corporate social responsibility practices from deception to authenticity. And in fact, this one is 8th, and it's about caring principles and practices in CSR again. And caring is in fact a kind of example or paradigm of authentic, as previously in previous remark explicated authentic CSR. One paradigm case is care or caring actions, as we will explain in what follows. Now I need to add something concerning the previous remark. In previously mentioned paper, that remark was only explicating a part of it, basically the argument and some explications of arguments, premises, and some conclusions, context of conclusions. Okay, now in all these accompanied papers, my colleagues and myself, we always try to supply a particular case at the end or sometimes in the middle of the paper, depending on the structure of a paper and of research. So in the previous remark, the case was of a Hoto Group construction company in Croatia, and at that moment this was quite a big case in Croatia, in Zagreb especially, in Croatia's capital, and in fact in one of the most beautiful squares in Zagreb. And the case was about a series of allegations that and raised doubts about the group and its owner, Mr. Croatia, that the company was engaged in a series of CSI activities. Nevertheless, all of these were dismissed at court, as far as I know. By now, I'm not sure. However, the case was directed toward a particular event that happened, and even that was noticed in New York Times as well. So it is of some importance as far as New York Times is important. Now the issue was that there is a special kind of security fence over a construction site, which protects people moving around it from the construction itself, from the harms that activities on a construction site can produce toward passengers, pedestrians around the square. So this safety fence was in fact badly constructed itself, and it was broken, and it fell down on the pedestrian area, and it almost seriously harmed two pedestrians walking near to it at the moment. And this event was recorded by a security camera, and And Mr. Hrvaticic was asked in a state television, I believe it was a live interview or recorded, I don't know. Is he aware that his safety fence almost killed 2 ladies passing by his company's construction site? He said, no, the fence never fell down. It just leaned a bit, just a bit, nothing serious. And while he was saying this, in the same time, the video recording of the actual event was broadcasted, and in this security camera recording, it was obvious that the fence, safety fence, didn't lean a bit or moved a bit toward the ground quite slowly. Well, it moved toward the ground completely from vertical position to horizontal position in a few seconds. Well, we don't call this such event concerning the safety fence that it leaned a bit on the side of pedestrian area. It was completely broken, and it almost seriously endangered lives of two passengers, 2 pedestrians walking by at that moment. So the owner, the main of the company was caught in lying. He was trying to bullshit his way through, but he didn't succeed. He was caught. He thought that nobody would know about this event, so if nobody knows, he can bullshit. But it was presented at the news that what went really. So his I don't know how to say it. His attempt to bullshit end up as a quite bad case of lying. That's it. So this was, in fact, in the paper, this was the example of deceptive, of at least attempt to produce deceptive CSR. And what he should do, or in the particular situation, in order to be authentically socially responsible. Perhaps he should done something more, even for these pedestrians, before or immediately after the happening. And perhaps he should explain this explicitly while he was talking on news, but this was not the case. So this was the example of deceptive, at least attempt to produce a particular deceptive CSR. Okay, so much about the previous remark. I'm sorry, because I'm doing this remark, not the previous one. Now, this remark, as I said, concerns caring. Caring as something which is, which in our opinion, in opinion of co-authors of the paper, Caring Principles and Practices in Corporate Social Responsibility by Jelena Debeljak, Mirna Koričan, Kristijan Krkač, and Andrijana Mušura in Ethic, Psyche, like in German, mit Umlaut, Psyche, and Social Responsibility, edited by Ana Maria Davila Gomez and David Crowther. We think that caring or care is perhaps one of the paradigm cases of authentic CSR. And when we say that, we mean that there are there are at least two quite opposite standpoints, or quite opposite possible interpretations of caring, of human caring, of human care for each other, for environment, for all stakeholders. One element of caring is in fact condensed in a way in a drop of legal terminology and legal practice. And the opposite, this is one side of caring. And another side of caring is a kind of myth about caring, kind of myth that humans are species that essentially manifests extreme care toward others. Okay, towards some more and others less, of course. For instance, toward members of their own family more, and toward members of other people's families less, or toward animals less, or toward nature, or inanimate objects, I don't know, even less. Okay, now these two should be in a way confronted with each other, and we tried to create a kind of middle way between these two as opposites, in order to create some kind of to develop a kind of justification for a common sense intuition that caring is not just what is said in legal terms, or in terms of legal practice, neither in a way in which is described in the context of this myth about humans as especially caring species. Yeah? Okay. Now, according to, let me start with this myth. Among many different kinds of events, there are human actions of caring, such as, for example, a parent taking care of a child, or a manager taking care of her business. Okay, now, if we understand human actions as being morally right or wrong, in the light of their consequences concerning all relevant actions, then this description of caring fits nicely between two opposites. One is the grounding idea of market economy, which says that the market economy is essentially directed toward the future profits. As it was said by McCraw 2000, capitalists then are people who make bets on the future. The essence of capitalism is psychological orientation toward the pursuit of future wealth and property. On the other hand, pragmatist ethics principle says that the consequences of our actions are viewed not from the present action, to them as actualizing in the future, like in meal, for instance, but rather viewed from the future world that one is produced by performing certain action with its consequences, like in, for instance, John Dewey. So both morality and economy depend, in fact, on our present hopes regarding the future facts that, in fact, do not exist. That do not exist now. So this is a connecting point. So in view of this element, or this aspect of the myth, and this essentially correct aspect, because morality and economy and caring, in fact, are all concerned with the future. And this is essentially correct, this is essentially okay. But there is a lot of it around it that seems to be completely wrong, or at least seriously dubious. Now, caring is everyday and legal term as well. Let's state a few obvious remarks concerning care. care is exercise of caution and prudence in one's conduct so as to avoid causing injury or loss. Care can be ordinary care, due care or reasonable care, or utmost care, or as it is sometimes referred to, extraordinary care. In legal terms, negligence is a type of malpractice. Malpractice is negligence or other failure of professionals, such as a doctor, lawyer, manager, or accountant, to live up to reasonable professional standards in the performance of services for a client. Negligence is a conduct involving an unreasonable risk of injury or loss to others, or the conduct that falls short of the degree of care that a reasonable person would have exercised in the same circumstances. So this is in fact the table that we constructed in a way. I don't know if it is visible. I believe so. So we have, on one hand we have care, on the other side, other column is failure to exercise care. And now care can be ordinary or extraordinary. Failure to exercise care can be negligence, breach of fiduciary duty, or malpractice. And now, in terms of analysis of this common sense and legal aspects of caring or care, it should be said that this myth should be described properly. To take care of X by epsilon, as it were, means for epsilon to execute actions by which X will perform properly and without which X will not perform properly or even not perform at all, meaning that X will suffer certain loss, injury, harm, or damage. On the other hand, to act with care, contrary to take care, means something rather different. It is to act with something which seems to be added to the act itself and which can serve as its explication, not of the action itself, but to some extent as the explication of the manner in which the action is performed. So taking care as performing an action properly, or lege artis, regarding the standard procedure of a profession, and acting with care is a narrative which is the best story about what one as a professional does in terms of producing a better world compared to the present status of it by certain action and its consequences. In a situation where one is doing something more than taking care, and which can be conceived as something added to proper performance of an action or of a standard practice of necessary and sufficient care or ordinary care. So care is not caring action or caring act. Caring isn't a property of an action, nor it is a property of a doer, such as a caring person. Okay, there are different standpoints here, but we will mention some later on. In our opinion, this is not completely correct. So, for one thing, there is a myth about acting with care. There is no acting with care. We simply act in a certain manner, in a certain way, doing certain acts, performing certain acts, which have consequence toward the objects of our actions, sometimes persons, and this relation can be described or understood as caring action. There is nothing caring within the act itself or within a person. But regarding this ontic difference, there is nothing caring, or in other words, non-caring or careless in or about our actions. There is no caring aboutness of human actions. Caring is the way of seeing human actions. Caring is the way of talking about them, not the way of performing an action as a part of practice. There is no ontic power of acting with care or caring action as something added to lege artis performance of a particular action. Caring can exist in the mind of the performer of an action as the motive, goal, or emotion, and also it can exist in the mind of the person to whom the action is directed to as the benefit. but it cannot exist in the action itself. Action is action, simply it is what it is. Now, let us illustrate this with a quite simple, we think, also quite appropriate example. Here are two descriptions. Description A runs as follows: washing hands properly, and description B, washing them with regular care. In fact, these two, A and B, mean the same, because both A and B can be described in terms of the certain procedure of washing hands in order to make them sufficiently clean for a given purpose. So in fact, there is no normative addition in B. Let me repeat, washing them with regular care, as an act compared to A, washing hands properly. Although there can be, and in fact there is, a certain narrative addition to the very act of washing hands in terms of explicating the motive for washing hands, for example to a child, or explicating the purpose or goal as a certain value, for example hygiene, avoidance of illness, health, etc. Now, if there is no difference between A and B, and if there are a series of such cases, in fact parallel cases, then there is no really anything caring within a doer or within a beneficiary of an action, nor in act. The whole story can be told about the action, about the doer, about the person toward whom the action is directed to, as caring situation, caring practice, caring performance, I don't know, this and that. But there is nothing essentially caring within these elements. Now let us try to check this in a negative way. So let us quote the negligence as it was criterion of negligence. It was formulated by Judge Lernhand. We quote it from Boston 1983, page 4, referring to case US versus Carroll Town and Company. So Judge Lernhand said, the failure to take care, negligence is the failure to take, what we have here is a failure, oh, I'm just kidding. The failure to take care where the cost of care is less than the probability of the accident multiplied by the loss if the accident occurs. The product of this multiplication is the expected cost of the accident. Also, we should mention a so-called objective test of negligence, which says a person who considered a situation thoroughly and took what he genuinely regarded as a reasonable risk would nevertheless properly be found negligent if the jury concludes that a person of ordinary intelligence and prudence in that situation would not have done what the defendant did, really. So it seems that it is easier to understand what is regular care in terms of lack of care than to understand what caring really is. In other words, X is negligent regarding epsilon if X is choosing between practice alpha and practice beta, and X chose to perform alpha rather than beta, and where practice alpha implies action involving an unreasonable risk of injury or loss, or X is excluded, where a reasonable person is a person of ordinary, of course, ordinary intelligence and prudence, or the action that falls short of the degree of care that a reasonable person would have been exercised in the circumstances in which X was in time of choosing alpha and performing alpha. Now, say that A is a manager and B is an employee in a company. And now we should apply this negligence criterion to this particular case. And this is not This is not a complicated thing to do. So the criterion would run as follows. Then there must be a certain set of rules implicit in an action, or in short, a certain set of procedures. And A is by performing these actions or procedures displaying care, or A is taking care of B. And by not performing these actions, or by performing them only partially or incompletely, A is displaying negligence toward B. So it seems that care can be standardized in the terms formulating standard procedures of, for example, management of the company, or at least in terms of standard exceptions of procedures that must be avoided in order not to perform in a negligent manner toward the other stakeholders of a business in question. So application of the care principle is negative form of negligence, and in combination with the harm principle will result in the following principle for moral correctness in terms of authentic CSI. In order not to display negligence or any other kind of malpractice as a lack of ordinary care, any business activity should be conducted in such a manner that by itself or by its direct consequences does not produce any kind of irreparable damage or harm, or preferably, if it is possible, not to damage or harm at all, to any of its stakeholders, social, non-social, internal, or external. So, if we apply this combination of previously also applied criterion of negligence with combination with no harm principle, at least no relevant harm principle, no direct harm principle, then we can have in a way modified criterion of negligence, in a way that A is negligent regarding B if 1. A is choosing between business practice alpha and business practice beta, and A chooses and performs alpha rather than beta. 2A, where practice alpha implies actions involving an unreasonable risk of injury or loss to beta in such a way in such a way that the practice alpha by itself or by its direct consequences does produce any kind of irreparable damage or harm to B, or that the business person A or his actions, her actions, is such that it falls short of the degree of care that a reasonable business person would have exercised in the circumstances in which A, as a business person, was at the time of choosing alpha and performing alpha rather than beta. Now, this is in fact a criterion of negligence that can be applied in a series of standard business procedures, standard operating business procedures, in any business whatsoever. And by applying it, we think that two mentioned opposites are in a way criticized and bypassed. On the other hand, there is a purely legal consideration toward caring, which in its procedural part should be taken into account, but the kind of precision of it is too precise. It's too precise, and it doesn't take into account a lot of contextual elements, which are supplied by another opposite, which is the myth about caring. And if we remove this mythological part about humans as caring, especially caring individuals and even caring species, then perhaps it is possible to save this aspect of the myth, which is not mythological at all, which says that sometimes we can describe human practices, particular actions by particular humans as caring actions. That's it. But this is only a description. There is nothing essentially caring in terms of a property of an action or a feature of a doer of an action or concerning the consequence of an action, a benefit, for instance, towards some other person. This all can be described in this way, but this description doesn't correspond to anything. It is a story. It's not a myth, it's a story, but it's a description. And this description has its use in lives of humans, in social and cultural aspects of human lives. It's important. Now, if we understand this suggested criterion as kind of middle solution and as a paradigm case, one among series of paradigm cases there are others, of course, cases caring as a paradigm case of authentic corporate social responsibility, and avoiding a series of deceptive ways of caring, then we should imply or import various fine distinctions that can be and are useful in particular practical cases. For instance, a series of distinctions made by Nell Noddings, for instance, in the paper Two Concepts of Caring, in which she differs between, let me just supply a list of series of differences, distinctions within the concept and between various practices, perhaps. Natural caring, ethical caring, sympathy, receptive attention, a caring person, caring for, caring about. Now, these two last, caring for and caring about, are quite similar to our previously mentioned distinction between difference between to take care and to act with care. Now, what she says is the following: caring for is direct encounters in which one person cares for another, refers to a special attribute of relations, and as such, theoretically stands above caring about. And now, caring about, more generally, refers to a virtue, and takes us to a more public realm, maybe foundation of justice even. And this is in fact what should be used in a series of particular practical situations. These differences should be applied in order to understand better such particular cases. And why? Because we want to describe them in more perspicuous manner. And then such descriptions should also be understood as a kind of paradigm descriptions. Okay, so this was just a short remark concerning a part of our paper, especially concerning this conceptual part. We were not concerning with the practical cases, practical cases again. We used Croatian cases with which we are most familiar, and the case was mobbing in Croatia and ways in which persons suffering this unfortunate actions by others do not have any kind of serious or direct or quick and efficient protection within our society. Okay, this was the case. In, let me see when it was published. It was published 2007, so it was what 6 years ago. Nowadays, perhaps some differences, some improvements even are made due to the fact that Croatia will become, or in fact, really it is a member of European Union. So some general rules or directives of European Commission should be applied and will be applied, and therefore some more stringent policies toward mobbing cases would also should also be applied and will be applied by all means. So this was our case in this concerning this issue of caring, or in fact lack of care. This was the example of lack of care, the example of deceptive CSR, or in fact authentic CSI, authentic CSI. Okay, so this was just caring as just one among a series of paradigm phenomena, as far as we understand it, as a series of paradigm phenomena that we concern as authentic CSR. Authentic CSR, yes. Okay, that's it. Thank you very much. Okay, I forgot almost. Ninth remark would be about. Okay, this would be fun. This would be fun. Would be about another way of pointing toward authentic CSR by criticizing almost common understanding of CSR, corporate social responsibility. If one uses such account or such concepts of CSR, of business ethics, CSR, sustainability, etc., etc., then, and if one takes a series of quite different opposite examples, almost examples which do not share any similarity, then something strange appears. For instance, quite criminal organizations in recent history displayed CSR in a way which should be or can be understood as more authentic than any other example of CSR displayed by a non-criminal organization, legal organization. And then such cases points us back to the very concept and the criterion of CSR and forces us to reconsider it, because it seemed dubious. Now, if we have a concept of CSR that can be used in order to describe particular actions of particular criminal and illegal organizations as being completely, authentically responsible, then there is nothing wrong with these organizations. There must be something wrong with our concept of CSR, and we should ask ourselves, for which purposes did we created this concept? So this will be the topic of my next ninth remark. Thank you.